Law 529, Relevancy, Section 8, Lecture 1. Alright, we are going to proceed on to look at the provisions on general relevancy, which is in Section 8. Okay, now let's look at Section 8. Section 8 of the Evidence Act 1950, motive, preparation, and previous or subsequent conduct. 8 sub 1, any factors relevant which shows or constitute a motive or preparation for any facts in issue or relevant fact. Subsection 2, you have the conduct of any parties or any agent to any party to any suit or proceedings in reference to that suit or proceedings, or in reference to any facts in issue therein or relevant thereto, and the conduct of any person, an offence against whom is the subject of any proceedings, is relevant if the conduct influences or is influenced by any facts in issue or relevant fact, and whether it was previous or subsequent thereto. Now, if you look at these provisions, of the Evidence Act, basically you can separate Section 8 into 3 categories of relevancy. The first one is to show motive, and number 2 to show preparation. So motive and preparation are both under Section 8 subsection 1, while evidence of conduct basically under Section 8 subsection 2. Right? Now let's look at it here. Now let's look at evidence of motive. If you refer to the PowerPoint here, you got to basically understand what motive is. Motive is basically referring to a reason why a person does a particular act. You have this in the case of R and Steen, whereby this case basically distinguish motive from intention. You have other cases like Lower Perak Cooperative Housing and Ketua Pengarah Lembaga Hasil Dalam Negeri. Basically, this case also indicate that there are fundamental differences between motive and intention, whereby intention is basically seeking to do something and it is connected to the purpose or objects, but motive is referring to reasons why you do a particular act. Now, when you look at motive here, there are certain characteristic of evidence that show motive, whereby if you are to tender motive as evidence in the court, it must not be hearsay. That will be what stated in the case of Karam Singh. And motive must also not be general. It has to be specific to a particular crime. Alright, now let's look at some illustration on evidence of motive. So you go back to Section 8. You have Section 8 subsection. Section 8 of the Evidence Act. Basically under Section 8 of the Evidence Act, you have 8 subsection 1, you have motive and preparation. You also have under 8 subsection 2 conduct. Actually, when you refer to conduct, you will know that you are talking about conduct, either conduct of the accused person, conduct of a relevant third party, or conduct of the victim, right? And this conduct must have connection to the facts in issue, in the sense that the conduct here is either influencing or is influenced by the facts in issue. Maknanya, it means that when you talk about evidence of conduct, it cannot stand alone. You saw a person slapping, the victim slapping the accused person, or vice versa. You cannot give it evidence of conduct unless you can relate it to the facts in issue. So it must not stand alone. And when you talk about conduct here, you can either have previous conduct, or you also have subsequent conduct. Now, what does it mean by previous conduct here is that you have the facts in issue here. Previous conduct refer to what is your action prior to the commission of facts in issue. This is previous conduct, and subsequent conduct will be your action after the commission of facts in issue. That will be the subsequent conduct. Now we are going to look at Section 8 subsection 1 first. That is, you are talking about evidence of motive. You basically have the case of R and Steen give you the definition of what motive is. Remember, motive is not intention. Motive cannot give you the mens rea. it is kind of circumstantial evidence as well. Yeah, you can only bring motive as an example of circumstantial evidence indicating that the person may have motive to kill. Yeah, say you have a situation of Ali kill Mona, right? You have Daud here, the best friend of Ali, who basically know that Mona dumped Ali, right? And Daud also know of the fact that Ali was very upset, right? Ali was very revengeful, right? And he was very angry. So this is known by Daud because Daud perceived this incident. Yeah, Daud know of the fact that Mona dumped Ali, and Daud know of the fact that Ali was very angry because he perceived of the fact that Ali was angry. And later Mona dead. Yeah, okay, of course lah, Mona have a new boyfriend, katakanlah Zack, and maybe Ali has been confiding in Daud, and Daud also saw Mona and Zack going out together, and the fact that Ali was fuming as a result. So here, when Mona is now dead, Daud can give evidence of motive, right? Motive of Ali killing Mona, that could be jealousy, right? So remember, when you talk about evidence of motive, the case of Karam Singh, the case of Karam Singh clearly stated that motive has to be given by way of direct evidence. It cannot be by way of hearsay evidence. It cannot be by way of hearsay evidence. Now, to illustrate clearly on this one, now look at what happened in Karam Singh. It says that motive must be by direct evidence, not by hearsay evidence. Now what happened in Karam Singh here is that you have a situation where, okay, you have the father who has two sons, son number 1 and son number 2. The son number 1 could be the elder one, and son number 2 is the younger one. What happened here is that the father told the son number 1 here, young elder brother, saying that I will transfer all ownership of my business to son number 2. And when father confided that with son number 1, son number 1 was very angry, he was unhappy, and he was basically threatening the father, right? So this is what happened. And the next day, the father told son number 2 of the fact that his elder brother was very angry when the father decided to give the business to son number 2. Now later, if the father found dead, now is found dead, the facts and issue here is whether son number 1 here is an accused person, killed the father. Now you cannot call S2 here giving evidence of motive to kill. Maknanya bila S2 giving motive to kill, what happened here is that maybe S2 here is giving evidence to the court of the fact that my father told me that my brother was very angry, blah blah blah. So that will indicating motive. The law under Karam Singh says you cannot, motive cannot be proven by hearsay evidence. Okay, it has to be proven by direct evidence. Right? Another example, you have a situation, perhaps Ali killed Mona. Mona wrote in a diary, right? Mona said in the diary, I have jilted Ali, I'm free now, but Ali was very angry. He says that I cannot be happy, blah 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 semua. And then next day, Ali has been stalking me, whatever semua mentioned in the diary. Mona is now dead. You want to tender the diary. The diary is a hearsay evidence. If you want to tender the diary here to show motive under section 8 sub 1, it is not allowed. It is not relevant, not admissible, because the moment you do that, you are relying on the content of the document, which is hearsay. Therefore, it is not relevant, not admissible. Okay, get the picture. So this is what is the principle in Karam Singh, right? Whenever you have motive, evidence of motive, then it has to be proven by direct evidence. Now, how will that be done? Example of how this can be done. Now you have the case of the Mahat Tafiz. Remember the case of Mahat Tafiz? How does that incident happen? The incident started with right? You have the accused person here. Okay, you have accused 1, accused 2, and accused 3. They were maybe 3 of them. They were smoking cannabis. If you remember the case, near the lake, kat tepi tasik. And what happened here is that, the Tafiz students, the students here, passing by them, and they were whispering. They were looking at him and whispering against each other, and then they were giggling among themselves. And A1 and A2 and A3 here thought that these students are provoking, thinking that they were so good, dia ingat dia baik sangat, so they were very angry. And as a result, they were saying that let's teach them a lesson and let's burn the dorm. So this is what happened. If you recall the case of the Mahat Tafiz, you may have more than one accused person in the beginning. But later, what happened was that only perhaps A1 and A2 that is being charged. You have here the third friend here, A3, not charged. So if you have A3 here not charged, he becomes prosecution witness. So what happened here, if A3 here testify in the court, he will be narrating the event as to how the incident started, and his evidence A3 here bila dia narrating, kejadian tu bermula dengan macam ni, right? He was narrating. It could be relevant to section 6, same transaction. It could also be relevant under section 8 sub 1 to reflect the existence of motive of revenge. That will be the situation. So what happened here is that you must have direct evidence. So A3 now become the prosecution witness and testify orally in the court. So that's why it becomes direct evidence. Or you may have another situation, right? You may have another situation which can reflect motive. Katakanlah you have a situation where the company or the person is having financial trouble. Financial difficulties. Katakanlah the offense that you are talking about here is forgery. You are forging the check. Boss you punya check, right? Forgery of check. Now, the evidence of financial difficulties here may reflect the existence of motive why you forged the check in the first place. You are having financial problem. This become a motive why you forged the check. So what you have to produce here will be, katakanlah you have here A, he is committing an offense of forgery of the check belonging to the company, and as a result he withdrew some kind of cash, katakanlah RM 50,000, 50,000 from the check. So he was charged for forgery. So the issue here is whether he has motive to do forgery. You want to bring evidence of motive. What you got to do is that you relate evidence of motive dengan dia punya financial difficulties that which may cause him to commit forgery of the check to get the money. So what to produce in the court will be perhaps dia punya statement of account that is actually reflecting of him pending on, katakanlah, payment of loan. Payment of loans. So you produce a statement of account that reflect that he is pending on payment of loan. Credit card dia yang dah due, exceeding, maybe evidence of, katakanlah, PW1 that shows that this person is loaning from him some cash. So these are all evidence which may eventually reflect existence of motive to kill. Motive to do forgery. Now what I'm emphasizing here with you is of the fact that if you are to bring evidence of motive under section 8 subsection 1, you have to understand that motive is reasons why you do a particular act, and motive has to be given directly by a witness, or an evidence must be tendered to prove the existence of motive. Now you also have to understand of the fact that sometimes motive is not there in some cases. Existence of motive is not necessary at all time. There can be situation that there were no motive. It doesn't matter, because motive is actually supporting evidence to show, because it is circumstantial in nature. It does not show that you commit the crime because of what, but it is supporting that you might want to commit the crime. So because of that, it is actually supporting evidence. Now, if you refer to other law, you refer to other cases, you refer to maybe the next slides which I share with you, you will find that there are quite a number of situations where you can reflect the existence of motive. If you recall the case of Sunny Ang, the case of Sunny Ang, motive is actually to get the insurance money. That's why she killed her. So what you got to produce will be maybe the evidence of the insurer, the agent, the insurance itself, the policy. You have to produce the policy insurance in the court to reflect that, okay, to reflect that there could be possibility of motive, and the fact that Sunny Ang here having financial difficulties, okay, the hutang-hutang dia tu semua you can tender as evidence in the court to reflect the existence of motive. So it's quite simple there, yeah, on the motive, yeah. Also look at the situation, okay, that's the position. Okay, remember when you talk about the law of evidence, one point that you have to consider is where if you are tendering evidence which is relevant under one provision, yeah, under one section. Katakanlah you are tendering an evidence relevant in section 8 sub 1 to show motive. And it is relevant to show motive, you cannot use other section to prevent motive, evidence of motive from being tendered. What does it mean is that if you have, katakanlah you have one particular evidence, you want to produce it in the court, you can fit it into one of the provisions of the Evidence Act, katakanlah showing motive. You cannot use other provisions in the Evidence Act to prevent the evidence of motive from being tendered. This is what illustrated in the case of Wong Fo Hin. Yeah. Now what happened in the case of Wong Fo Hin here, which reflects that motive will not be prevented by you tendering other evidence to stop it. Now what happened in the case of Wong Fo Hin here, you have basically the daughter, you have the accused person who's the father, and you have the wife, and you have orang tua, ketua kampung tu. Now what happened in this case is that the accused person have been raping the daughter, right? Kat rumah, okay, they stayed at rumah panjang. Orang tua here is actually the ketua rumah panjang tu. So what happened here is that the wife got to know that the husband here is raping the daughter. So what she did was that she complained to orang tua. And orang tua called the accused person. Orang tua said to the accused person, if I hear that you are raping your daughter one more time, I will report it to the police. This is what said by the orang tua, ya, ketua rumah panjang tu, to the husband. So what happened here is that the husband stopped raping the girl until one day he came home. He asked the girl to go into his room and give him a massage, right? So she asked the girl to give him the massage kat dalam bilik dia, kat dalam kelambu, and he basically raped her, yeah? He attempted to rape her, and she screamed. At that time, the wife was actually in the kitchen. The wife stopped doing what she did, went to the room, yeah, passed by the room, saw the husband tengah betul-betulkan kain dia. Yeah, maybe the husband has raped the girl. So what she did, the wife did, was that she left the house. The wife left the house, leaving the daughter and the husband alone. Now, what do you think is in the mind of the accused person when he saw the wife being so angry and leaving the house hurriedly? So in the mind of the accused person here, my wife is going to complain to orang tua, lepas ni habis aku pergi kena tangkap polis. That is what in the mind of the accused person. Alright? The wife came home at night. When the wife reached home at night, she looked for the husband and the daughter. Both of them were not home. Dua-dua tak ada. And the next morning, the husband came home. The daughter was not around. So she got curious, reported it, and they are making a search of this girl. 3 days later, they found the body of this girl, here. The body was actually dumped. Yeah, the body was actually dumped in a well dalam Perigi Buta, about 1 mile away from the house. Right? Further investigation was carried out, and you have here the accused person now being charged for the murder of the daughter. Now, that will be the facts and issue whether A here killed the daughter. Now, in this situation, the public prosecutor want to call the wife and orang tua. And the public prosecutor aim is actually the wife and orang tua here can give evidence relating to the existence of motive that the husband may want to kill the girl because he want to prevent her from telling that she has been raped. Because that could be the motive, yeah. Because remember, the orang tua has threatened him that if this happen again, I'm going to report it. So prosecutor is going to give to call the wife and orang tua to reflect that the husband here has a motive to kill the girl to silence her, so that she will not be able to tell what is actually transpired on that particular day, right? Now, in this situation, the defense, however, try to rely on Section 54. Yeah, Section 54. Now, have a look at Section 54. What can you find in Section 54? Now, if you refer to Section 54, okay, you can see Section 52, yeah, Section 52 until Section 55. This will be evidence that relates to character. We are talking about character evidence. Now, starts with Section 52. We are talking about character evidence in civil cases. It's not going to be relevant here. Now, this subject on character evidence, you are going to study further in your evidence too. Yeah, but in the context of the connection between motive and character, yeah, in the case of Wong For Him, this is what I'm going to discuss with you today. You look at Section 53. Section 53 says that in criminal cases, previous good character relevant. In criminal proceedings, the fact that the person accused is of a good character is relevant. Now, this is said in Section 53. It means that katakanlah you have an accused person here who is being charged for bribery. And the accused person here can give evidence of his good character. Maknanya dia boleh beritahu kat mahkamah he has been charged for bribery. So he is giving evidence of the fact that he is a very generous person, or even though he may take the bribery, but he is very generous in the sense that he like to donate to the masjid, right? He like to donate to orang-orang miskin. So you are bringing evidence of good character, right? Now, the law under Section 53 says that evidence of good character will always be relevant in criminal cases. So, boleh bawa evidence of good character, right? Tapi the catch here will be under Section 54. Look at Section 54. In criminal proceedings, the fact that the accused person has a bad character is irrelevant. So, under Section 54 disallow any attempt to bring in bad character evidence. So, bad character evidence under the law is generally not relevant. So, you cannot say, so A here committed bribery, right? You cannot tell the court of the fact that A here is a person of bad character in the sense that he like to frequent prostitute. Dia suka pergi jumpa prostitute. You cannot tell the court of the fact that A is a very stingy person dalam the court, like to frequent prostitute, suka mabuk-mabuk, suka jumpa ada kekasih gelap, katakanlah. So, if you bring that evidence, you are tarnishing the character of the accused person. Section 54 says that is not allowed. So, Section 54, Subsection 1 here, protect the accused person from any attempt to bring bad character evidence against him. Okay? Now, let's read further on Section 54. In criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. So there is a catch. Maknanya, as a general rule, you cannot bring bad character evidence unless, kecuali you have given him good character evidence. Maknanya, if the accused person during trial give evidence of his good character, nanti kita akan tengok macam mana ya in evidence 2, how it is done. So, accused person is giving evidence of good character. Maknanya, maybe the lawyer cross-examine the witness eliciting good character evidence. The moment that happened, the shield under Section 54, Subsection 1 against bad character is broken, in the sense that automatically, the moment he give good character, all his bad character evidence can be produced in the court. That will be Section 54, Subsection 1. Yeah, the second part of the provision. You got the picture? So the second provision of Section 54, the second link of Section 54, is actually to allow the tendering of bad character evidence if you have given good character. Right? Now, how do you relate it with the case of Wong Po Hing? Dalam kes Wong Po Hing, when the prosecutor want to call the wife and orang tua to give evidence of motive, the accused person says that, stop, you cannot bring these two persons because these two persons is going to be giving me evidence of my bad character. These two persons will tell the court, will reflect to the court of the fact that I am a very bad father who raped the daughter. This is injuring my character. So I am going to use the protection given under Section 54. This is what the defense was saying. Now, how did the court decide? Now, in this case, you'll find that the court says that if you have one provision of the Evidence Act allowing the evidence to be tendered, like in this case to show motive, you cannot use other provision to prevent the operation of that section. So it means that the evidence of motive under Section 8, Subsection 1 can be tendered, and Section 54 cannot be allowed to prevent evidence of motive from being tendered. You got the picture? Alright, so that will be an example of motive. Yeah, I hope you get the picture, and some of the further examples can be seen from your textbook. There are quite a number of examples to reflect how motive is actually being obtained. Okay? Now, secondly, if you look at your PowerPoint just now, you have 8 subsection 1, evidence of preparation. You give evidence in the court, you bring evidence in the court to show preparation. Now, what does it mean by preparation? Okay, when you look at preparation, preparation is basically referring to, you have the case of Lakshmi Prasad, preparation is referring to devising and arranging means necessary for the commission of a crime. Right? Now, preparation and attempt are two different things. Yeah? Maknanya preparation, you're referring to the act of devising, arranging. If you have obstacle, you basically remove the obstacle, whatever you have to do prior to the commission of the crime to ensure that a crime eventually can be committed. That is preparation. Maknanya this will be what happened before the crime is being committed. You are arranging, devising, preparing, ensuring no obstacle done. So that is preparation. If you look at the case of Tangya says that there are 4 stages in the commission of a crime. Yeah, there are 4 stages in the commission of a crime. You basically have, number 1, the formation of intention. If you have intention to kill, yeah, you said to your best friend, I want to kill my husband, I want to kill my boyfriend, how dare he jilted me for a freshie. You have intention, aku rasa nak macam tikam dia, you have intention, he eventually die, being murdered by someone else. You will not going to be blamed because you only have the mens rea, you don't have the actus reus. So there will be no liability. Alright? Number 2, the second stage in crime is actually having preparation. You prepare the commission of the crime. You beli barang, yeah? You beli pisau, you beli racun, you are preparing it. But you don't do it. You don't commit the crime. He eventually died. Preparation is not liability, but preparation may be part of circumstantial evidence to show that you are actually doing something towards the commission of a crime. So that is preparation. The third one is an attempt. Attempt is an offence in Malaysia. So if you want to kill yourself, you go to the highest level, kat tempat ketiga tu, naik tingkat 4, you jump but you don't die, you may be liable for attempted suicide. Yeah, attempt is an offence in Malaysia. You have attempted suicide, attempted murder, and so many attempts liability. Yeah, so attempt is not an offence. And number 4 is actually the actual commission of the crime. here you have both the actus reus and the mens rea. You actually done that. You are actually committing that. This one is where you have whatever you want to kill him and you manage to kill him. Attempt, maybe you want to kill him but he did not die. You nak tembak dia, terkena bahu dia. So instead of he died, he suffers from injury or he turned into a coma. You can be liable for attempted murder. But when you talk about actual commission of a crime, you want to kill him, you actually manage to kill him and he eventually died. So itu adalah actual commission of crime. So that is what it meant by preparation. Okay? Now, motive and preparation, not so much of a problem. The one that is more problematic will be when you are dealing with conduct, right? With evidence of conduct. Now, when you talk about conduct, bear in mind, the section will be section 8, subsection 2. Now, let's look at your PowerPoint on conduct. Okay, now let's look at evidence of conduct. When you refer to section 8, subsection 2, when they talk about evidence of conduct, 8 subsection 2 conduct is referring to, as I told you just now, it can refer to the conduct of the accused person, the victim of a relevant third party. Remember, when you read section 8 sub 2, you must bear in mind that the conduct is relevant if the conduct influences or is influenced by any facts in issue or relevant fact. So it means that there must be connection between the conduct and the facts in issue. It must not be in isolation. Now, what is actually conduct? You look at explanation number 1. Explanation number 1. The word conduct in this section does not include statements unless those statements accompany and explain acts other than statement. But in this explanation, it does not affect relevancy of statements under other sections in this act. So, dalam section 8, subsection 2, explanation number 1, statement is not conduct. Statement is not conduct. Kecuali statement that accompany or explain acts, that will be conduct. So, pure statement is not conduct under explanation number 1. Tetapi statement explains or accompanies action can be conduct under explanation number 1. Statement resulted in action can be conduct under explanation number 1. Now, how does that happen? Let's look at example. Right? Now, when can, so maknanya, conduct when refer to conduct, 8 subsection 1, explanation 1, statement alone is not conduct. Statement alone is not conduct. Say for example, I have my son who is 6 years old. So he is being, my son is being messing up with his toys. So dia ada mainan dia, toys. So he messed up the toys, right? And then I said to him, did you tidy your toys? Dia pandang kat muka I je, dia buat tak tahu je. I made a statement. Is that conduct? Now that only a statement, it is not conduct. When I said to him, he just took no notice of me, he just playing and messing up dia punya mainan. So when I made a statement, did you tidy your toys? That is not conduct. Because it is a pure statement and it does not have any reflection on my statement does not have any reflection in the sense that it does not result in any action by anybody. But when I say to my son, I said to him, did you tidy the toys? And I hold in my hand rotan. So, I pegang rotan, I pandang kat dia, did you? I just pegang dia gitu, did you tidy your toys? And eventually, he look at me, quickly he tidy his toys. So, I have my statement plus his action. What is his action? Tidying his toys. Now, so my statement resulted in his action. Right? It resulted in his action. Then my statement plus his action will be regarded as conduct under section 8 subsection 2 illustration. So explanation number 1. So that is statement plus action. Maknanya my statement resulted in his action. It is not alone. Or my statement explains action. Okay. You have someone here Katakanlah you are standing at your shop. You are in your shop. Someone came to your shop looking nervous, quickly ask you, tell you, jangan beritahu kat polis, saya nak sembunyi kat sini. This person come to you and said to you, and he quickly hiding dekat belakang pintu. He's hiding at the back of the door. And then police pass by, and I said to the police, police dekat sini. I said to the police, right? My statement here, I cakap police, I panggil police. And the action will be the action of the person who was hiding behind my door. Quickly he ran away through the back door. So my statement here, perkataan saya cuma perkataan police resulted in his action running to the back door. So my statement plus his action will be conduct. Got the picture? So conduct must reflect action. There must be a degree of action. Sama ada the action is influence or influencing. Sama ada conduct must reflect action. If you talk about statement, the statement must reflect some kind of action eventually. Then it will be conduct. Okay, you got that. So that is what it meant by conduct. Conduct refers to action. Statement is not conduct. Can there be a situation where statement can be conduct? Can statement be conduct? Maknanya you produce a statement and you produce it under section 8 subsection 2 as conduct. Okay, on this point you got to look at section 8 subsection 2 illustration J and K. This is where you may have situation where statement can be conduct. Statement can be conduct. Now let's look at section 8 sub 2 illustration J. The question here is whether A was ravished. The fact that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which and the terms in which a complaint was made are relevant, and this will reflect the conduct of the complainant. Right? So maknanya under section 8 sub 2 illustration J and K, statement can be conduct provided that it is a complaint. Statement can be conduct provided that it is a complaint. Now what is a complaint? What is a complaint? When you talk about a complaint, you got to look at the case of Aziz bin Muhammad Din. The case is Aziz bin Muhammad Din. The case of Amit bin Terang also talk about complaint. Now complaint, even though it may be in a form of a statement, it is more than a mere statement because it is expression of feeling. It is expression of your feeling. Now complaint, for it to be a complaint, it has to satisfy certain condition. It has to satisfy certain condition for it to be a complaint. Now, what are the conditions for a statement to be a complaint? A statement is regarded as complaint if number one, the statement has to be voluntarily made. The statement has to be voluntarily made. So maknanya the complainant made the complaint maybe at the police station to any person in authority. He must made it voluntarily. Maknanya there must be no element of force for him to make a complaint. Number two, the complaint was made with a view to punish. With a view to punish or to seek redress. Maknanya the reason why you make a complaint is that you want something to be done to punish him ataupun to prevent him from stalking you. Katakanlah there is a stalker, with a view to punish or redress. Maknanya you are seeking something extra, And number four, complaint has to be a complaint if it is made to person in authority. Now, person in authority with regards to a complaint is not necessarily be the police officer. Person in authority will be an authority in the context of the circumstances. If you have UITM law faculty, who is the person in authority for you to make a complaint to? If you make a complaint to me, I'm a mere lecturer, I cannot take any action. You have to make a complaint to either the dean or the TDs, those who are holding some kind of authority. So that is what it meant by person in authority. Kalau you bagi komplain dekat I, you cakap cikgu ni tak datang kelas, I can only tell to your KPP or to your dean, and then it may not move on further until you complain it yourself. So that's the complaint. So it has to be voluntarily made with a view to redress or punish made to a person in authority. Alright? And it has to be made as soon as possible. Right? It has to be made as soon as possible. Maknanya this one you got to look at the facts of the case. Soon as possible doesn't mean immediately. It depends on the circumstances of the case. Now, if you recall the case of Aziz bin Muhammad Din, what happened? Remember Aziz bin Muhammad Din? You have here a man who is 21 years old, who has a girlfriend. Accused person 21 years old, the girlfriend is 15 years old. Right, 15 years old. They spent the night at the friend's house, H. H has a wife. The wife is delivering a baby. So basically left the house. G and the accused person and the girlfriend had sexual intercourse. In the house. So when she came home the next day, the father was very angry. The father basically forced her to make a police report. Right, to make a police report. She refused because this is her boyfriend. Now in this case, in the allegation of rape here by the prosecutor, she eventually made a police report, so they pergi kat police station. She made a police report. The issue here, can you tender this police report or not? And why are you tendering this police report? If you are to tender this police report to show conduct, because it is a complaint, then basically it failed the requirement of a complaint, because in the context of the case of Aziz bin Muhammad Din, the girl did not make the police report voluntarily. Right? Voluntarily. So she did not make a police report voluntarily. By virtue of that, the police report that she made cannot be brought in to show evidence of complaint. Cannot be shown as evidence of complaint. Therefore, it cannot be reflective of evidence of conduct of the complainant. I give you another example. Say you have a situation where Ali killed Mona. Right? Mona dumped Ali. Right? And Ali, as a result, now was very angry. So he has been stalking her. So he has been making threatening calls to her. Now what happened here is that Mona kept in a diary. Right? Mona kept in a diary. She basically write down in the diary, I have jilted Ali, but however, hari ni je dia call 10 kali. Semalam dia call saya 13 kali. Lepas tu, he's been stalking me. He has given me, mayat kucing mati ke whatever. So, Mona wrote it down in a diary. Can you produce the diary here if Mona is dead? Mona diary here cannot be verified in terms of the content. So, Mona's diary here is a hearsay evidence. Now, if Mona diary is a hearsay evidence, you have to bring it under exception to the hearsay rule. Maybe under section 32 later when we discuss this one. It's actually under 32 sub 1 sub A. So, Mona's diary here, it failed. It cannot be regarded as complaint because it is not made to person in authority. It is not made to a person in authority. Katakanlah, right, Ali has been stalking her. She made a police report. So Mona go to the police station, made a police report. So Mona wrote down the police report saying that, okay, Ali has been stalking me, he has made threatening calls to me, blah, 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 blah. So he made the police report. Now she is dead. Can you produce the police report as evidence or not? Katakan dia dah mati selepas sebulan daripada making the police report. Can you tender the police report or not? The police report here can be tendered to reflect Mona's conduct. It can reflect Mona's conduct walaupun dia adalah statement. Why? Because in this context, Mona is a complaint made to a person in authority, blah blah tu semua. And if you refer to Section 8, Subsection 2, Illustration J and K, you find that it reflects Mona's conduct because it is concerned with the circumstances under which and the terms in which the complaint was made are relevant. So, maknanya if you are to tender this police report made by Mona, katakan on the 1st of January 2020, you want to mark it as exhibit. So, prosecutor want to produce this evidence and mark it as exhibit, right? It can be tendered as evidence of Mona's conduct, right? Reflecting of her fear. Why she made the police report? Because she was in fear of her life, because she has been threatened by the boyfriend. So it reflects Mona's conduct. Maknanya you are concerned with the circumstances as to why she made the police report. So you are talking about Mona's conduct here. Why is it that you cannot show Ali's conduct? Why can't it show Ali's conduct? You cannot show Ali's conduct because, right, the moment you show Ali's conduct, you are basically relying on the content of the police report which no one can verify. So to do that, you are basically relying on a hearsay evidence, therefore it is not relevant, not admissible. That's why when you have a complaint, you are not talking about the conduct of the person that is being complained. Instead, you are talking about the conduct of the complainant, the person who made the complaint. You got the picture? Alright, got that, yeah? So that will be on evidence of conduct. So if you look at this one, yeah? So you have Section 8 here. We are talking about conduct here. You can have previous conduct or subsequent conduct. And whose conduct are you talking about? It is either the victim, relevant third party, or the accused person, right? So here we look at situation here, which I have explained to you just now. Conduct refers to action. Statement is not conduct, but statement can be conduct if it fall under one of that, and statement is conduct if it is a complaint. Yeah, you have that case to illustrate to you, right? So this will basically be the law relating to Section 8 on evidence of conduct. You may have quite a number of examples here to reflect what does it mean by subsequent conduct, previous conduct. You can have that in the textbook, which reflect to you evidence of subsequent conduct, examples of conducts, yeah, under Section 8 sub 2. Alright, with this, I complete discussion on Section 8 sub 2.